Good evening, everyone. And today, amongst us, we have the senior advocate from the Supreme Court of India, Mr. Mohan Katarki, and all those who have been connected with Beyond Law CLC know it very well that he has taken earlier sessions with us, and they have gone extremely well. And that's why when topics more specifically under the Constitution of India comes into being, we request Mr. Mohan, and he has always been kind enough to share his knowledge. The topic, which is very relevant for the purposes of students, judicial exams, lawyers, and how the journey has traveled, that is equality, rule of law, and justice under the Constitution of India. This important aspect being taken up on a weekend itself shows, and the way the people are watching it on the YouTube shows that people are glad to understand that. Without taking much time, I will request Sir to share his knowledge. Over to you, sir.
Thank you, Vikas. At the outset, I thank you as well as those who have joined to hear this lecture. The subject on which I'm going to speak is a bit dry and dreary. The word equality excites everyone. But if you ask me, which is the most complicated concept in the political science, it is equality. Somehow, the legal theorists have been able to put a test of classification and later arbitrariness to control the meaning of equality or equality in rights. Nevertheless, equality has many dimensions, and what is equality may mean unequal to somebody. What is unequal to somebody may mean equality to someone else. So this topic, apart from legal interest, has huge political interest. As we see day and night, both sides in the political spectrum talking on the same topic, saying that what you have done is not correct. This amounts to treating people in a discriminatory manner. This amounts to pampering people. This amounts to sort of distributing freebies to the people. All these things emanate from the concept of equality, because equality itself is a very difficult concept to be defined. To begin with, what is this equality? From where did it come? Why did it come? Historically, it is a facet of justice. There's nothing like a separate idea. The state, which is founded on social contract theory, again, it is a theory. It is assumed that it has its birth in the consent of the people. If it has birth in the consent of the people, that means those who are all consented for the formation of the state have to be treated in turn equally with regard to their liberties and rights. So that's how the concept of equality emerged. It became a very exciting concept in the age of enlightenment in 16th and in 17th and 18th century. Finally, it took its shape in the form of a legal mandate sometime in the middle of 19th century. I must say that it almost went for 2000 years, because even Aristotle spoke about equality as a facet of justice. He said that if there is no equality, there is no justice at all. That's how he put it. Then finally, when it took a shape in United States of America in the form of 14th Amendment to the Constitution, it took its birth in the different context, that is in the context of the Civil War, where there was a lot of discrimination between the whites and the blacks, who were the Negroids, who had come to United States of America or who had brought to United States of America as slaves. So in this context, the article was enacted in the United States of America in 1867. But initially the judges in the Gulf case way back in 1897 gave the meaning to equality only confined to the discriminations in case of racial discrimination. If the discrimination is based upon the race between the whites and the black, then the concept of equality or the mandate against the state, that is, state shall not discriminate, will arise. Until then, the court said it will not apply. But later, in the United States of America, the concept received its wider acceptance. Judges said it is couched in the general language. Therefore, it must apply to all actions of the state. It may be action with regard to the economic matters, social matters, or anything with regard to the regulatory matters, which in the US they call as exercise of police power. So with regard to all the actions of the state, the equality applies. That means the state actions cannot run contrary to the rule of equality or cannot treat the rights of people unequally. That's how the concept emerged in the United States of America. In India, as we adopted the constitution, the first and the foremost thing was incorporation of Article 14 and 15, 16 to translate the doctrine of equality into specific legal mandate against the state. This legal mandate, first of all, is only against the state. You cannot claim, you cannot ask your neighbor to treat you equally, or you cannot ask someone else to treat you equally. That's a separate, because this is not a guarantee against the private action. All private actions are free from the obligation to observe the rule of equality. You can contract, you can sell your goods to anyone you like. There is no principle of equality that before selling, you should issue a tender or you should offer it to all. And finally, you can choose the best price. Nothing like that. The private actions are immune from equality. But the state actions, which are more important, have to meet the test of equality. The test of equality has arisen in this context. It's a different matter in the United States of America and as well as in England now. Though in England, they do not have the doctrine of equality to test the state action, but there is a law that private action cannot be discriminatory or against the rule of equality. Same thing in the United States of America. The private actions are also now tested against the doctrine of equality. In India, also there is a proposal, a bill is pending as the private members bill to introduce and make the doctrine of equality applicable to the private actions. So the private actions are separate. Now let us concentrate on the state action where the doctrine of equality applies. So what does it mean? Article 14. Article 14 has two mandates. One is it confers a right upon the individual that you have a right to be treated equally, to be protected equally. That is your basic right. At the same time, which is more important, it's not just a right of an individual. It is a specific mandatory obligation of the state not to treat anyone unequally, not to cause any discrimination in any of its dealings as a state. Normally, when a state acts, according to us, we classify broadly under 6 types of actions. First is right of eminent domain, that is right to acquire the property, which state always has. Number 2, right to do the business, which state can, like any individual, do the business. Third is right or power to regulate the conduct of the people, that is the regulatory power, which in the United States of America, they call it the police power. The meaning is same, regulatory or police power. The fourth, what we see is the power to tax. It's very important because no government can run without taxing. But while taxing, you cannot discriminate. That follows. So this is how the governmental functions are divided. Then we have the duty of the government to protect its territory from the enemies. That is something which the government is bound to do, which it is the fundamental obligation as a state, even under the international law. It is its duty to protect its border. So this is how we broadly classify the governmental powers. Besides, there is a power to issue currency, because the government alone has the power of currency and the power to regulate the banking activities. Besides, there is also a power to conduct the elections, so that we have a democratically elected representatives of the people. In any of the governmental actions, particularly when we come across the regulatory powers which affect our liberties, and the powers of the government which deal with the distribution of the state largesse, that is the state's benefits, which may including the employment, which is also a privilege, the government has to observe the rule of equality in its actions. Now, if this is the rule of equality, then does it really work? If the rule of equality is to be literally applied, the government cannot make separate laws for anyone. It cannot exclude any class of people from any of the measures it undertakes. Suppose it prescribes, I'm just giving an example, that license shall be issued only to those who are above the age of 18. This is the law which classifies between those who are below 18 and those who are above 18. Suppose there is rule of equality is to be strictly applied, then all have to be given license, which is not possible, because a license is issued to those, it is issued to those who are having a mental capacity to drive the vehicle, who have reached that age, then only grant. Therefore, the state has a right to classify the people and discriminate. So strangely, the concept of equality, as it has developed, it becomes more a concept of inequality. There has been a lot of comments on that. But it is not just inequality, it is the justified discrimination which is tolerated, not the unjustified discrimination. So in the final reduction, the doctrine of equality is right against unjustified discrimination. If there is justified discrimination, the court will uphold it. If it is unjustified discrimination, court will strike down. So the doctrine of equality, which we talk about under Article 14, 15, and 16, in its last proposition is reduced to a right against unjustified discrimination. If you look to Article 14, it's a declaratory nature. But the next Article 15 is interesting. It prohibits any discrimination only on the ground of sex, race, caste, or place of birth. So word only implies that you can discriminate people, but only on this ground you cannot discriminate, which follows the meaning that the state may classify the people when it takes up any regulatory measures, or when it distributes its largesse, it can classify the people, but the classification cannot solely be based upon these prohibited grounds under Article 15, 1 and 2 of the Constitution. These are sex, race, caste, place of birth. So you cannot say, since you are a human, you are not eligible for certain benefits of the government, or you are not eligible for employment. It cannot be said so. But there could be a situation where the employment, the sex can be one of the factors, along with other factors. One may argue that it is not permissible for the woman to we engage in particular activity. But nowadays, with the progressive ideas, as you have already seen, even in the matters of the recruitment to the army also, the courts are not willing to accept that there can be any discrimination with regard to women on the ground of sex. So the things are changing even with regard to that. The Article 14 has several dimensions or facets. Most important facet is that you treat equally those who are equal. Those who are not equal, you don't have to treat them equally. Rather, it is an obligation on the government to treat them differently so that their uniqueness, their separateness is protected. So two things follows from this, that if X and Y are similar, the state must treat them similarly, except when there are good reasons to classify and discriminate. So if two persons X and Y are similar, then state must treat them similarly unless the state finds there are good reasons to discriminate them and it is able to justify those grounds if challenged in the court of law. That's how the first principle. The second is, if they are not similar, assuming that X and Y are not similar, then they shall be treated dissimilarly or separately unless the court state thinks that similar treatment is justified for good reasons. So this is how the doctrine of equality, two sides of the coin, are operated. If we are similar, we should be treated similarly unless there are good reasons for the state to treat you in a different manner, that is justified discrimination. Next is, if you are different, if you are not similar, then the state must treat you dissimilarly unless there are good grounds for the state to treat you, that is justified discrimination. Put it in a different way, the liberties of X and Y who are similar or same should be restricted equally or in equal measures. If X and Y are similar, their liberties, their right to or their freedom of speech or their freedom of business or freedom of association, on whatever those freedoms are to be exercised by an individual. If the government, for some reasons, wants to put a restriction, then the restrictions should be put equally unless government has good reasons to justify the discrimination. That is a justified discrimination. Now, similarly, if the government has policies to distribute a largesse or the money to the class of people, then it must do it equally unless it has good reasons to classify the people. For instance, you must have come across recently the PM Kisan, right? The funds are given to the farmers who are small farmers. The large farmers are considered to be not the same as small farmers. Therefore, the discrimination between the large farmers and the small farmers is justified in the matter of distribution of the Kisan funds. This is how the law does it. The principle is, if you classify, you can't do it arbitrarily. That's not your privilege. But the classification which the government does must have nexus to the object sought to be achieved. If the object sought to be achieved by granting the PM Kisan is to help a farmer to overcome the distress, to overcome the failure of monsoon, to overcome the indebtedness, then the classification between the rich and the poor farmer is justified because it has a nexus. That's how the rules are justified, even if they are discriminatory. Then we go to the how the Article 14 is caused. If X and Y are similar, excluding X from the benefit is discrimination against X, except for good reasons. That's already stated. Then we proceed to the next. What is the affirmative action? The affirmative action is under the Constitution, as I already said, the government has always the power to classify the people, classify it in such a way that the classification has a nexus to the object sought to be achieved. But what happens when somebody is unequal? Is government under an obligation to provide some help, right? Restricting the liberty is different from providing a positive help to the citizens. That's called affirmative action. The affirmative action is to create an atmosphere where the unequals become equal because of the compensatory policies of the government. So these compensatory policies of the government are provided in Article 15(3) and Article 16 also, with regard to the employment, that the government is free to make a reservation on the ground of socio-economic backwardness. And such a reservation cannot be questioned because it is permitted as an exception to the rule of equality in Article 15(3). Assuming Article 15(3) was not there, even then discrimination in favor of socially and economically backward people could have been justified on the basis of Article 14 itself. But however, the constitution makers thought that we need not wait for the court interpretation. Why can't we have a specific article which gives a power to the government to create a compensatory policy of reservation to protect the backward class people who have been historically wronged, against whom historically injustice has been committed. But this policy of the government, though it is styled as affirmative, that is the duty of the government to provide, but strictly speaking, as presently it has been interpreted, it is an enabling provision. There is no obligation on the government that it ought to provide a reservation. It is left to the discretion of the government, having regard to the conditions of employment. If they feel that there is no representation, then the government would be justified in taking the action. So there is no obligation that one ought to do, but the government, if it feels that there is underrepresentation, then they can take up the compensatory policy action. This is how Article 15, 2 and 3 and read with Article 16 permits an affirmative action for the purpose of distribution of any wealth or in the matters of employment. Now, going to the classification test, there has been a lot of debate in these days. First, this classification test came into picture long back in United States of America. Thereafter, when we adopted the Constitution, in one of the first case, that is Anwar Ali Sarkar case, State of West Bengal versus Anwar Ali Sarkar case, the question of classification, the test came into picture. The West Bengal government passed an ordinance creating a special courts for to try some of the offences which the government by a special or general order assigns. This was challenged on the ground of violation of Article 14 because the first principle of equality is, even otherwise, if you look at a larger principle of equality, that everyone should be tried before ordinary court of jurisdiction. The special court cannot be permitted to try the offenders at the sweet will of the government. Therefore, the Special Court Act was challenged, and while considering the challenge to the Special Courts Act, the Calcutta High Court full bench struck down, and when the matter came to the Supreme Court in the state of West Bengal versus Anwar Ali Sarkar, the Constitution bench upheld the judgment of the Calcutta High Court and firmly laid down the classification test, that is, the state is free to classify the people, and the classification must have nexus to the object sought to be achieved. And this test of classification, twin test, was not satisfied in Anwar Ali Sarkar case because the court said that there's nothing special about these offenders. They are like any other offenders, and the government cannot have discretionary power to send some cases to the special court and let some cases be tried by a court of ordinary jurisdiction. This is a prima facie a discrimination which cannot be permitted in any country ruled by rule of law. There has to be equality, and there cannot be any ground or justification. Of course, later, you all know, in 1978, after the emergency, the Janata Dal government, then Janata Party government under Morarji Desai, decided to enact Special Court Act. First, the bill was introduced and the bill was passed in the parliament. Then, under the popular demand, it was referred to the Supreme Court under Article 143 for its opinion, that is a presidential reference. And the Supreme Court upheld the law by distinguishing itself from the Anwar Ali Sarkar case on a ground that the offences committed during the period of emergency with regard to the officials form a separate class. If they form a separate class and that class requires a speedy remedy, speedy adjudication or speedy trial, then the state would be justified in creating a special court and assigning all those class of cases to the special court. So this is how the distinction was made from Anwar Ali Sarkar case, where the cases were assigned by the government at its discretion, whereas in special court bill, cases are sought to be assigned to the special court with regard to the offences committed during the period of emergency, when fundamental rights of the citizens were suspended, when there was a regime of autocracy in India. So that kind of a distinction which the court justified. The test of classification has served its purpose, but in 1974 itself, Justice Bhagwati felt that the test of classification is not sufficient to protect the equality of people. Most of the cases of equality go unaddressed. The better test would be to treat every arbitrary decision as the one which results in inequality. As a result, he laid down that better test to test the actions of the government, whether it violates Article 14 or not, is to apply the test of arbitrariness. Now, this test of arbitrariness has been applied easily in respect of executive actions or administrative actions, where the court can easily scrutinize based upon the affidavit filed by the state, whether the action taken is arbitrary or not. If the action is reasonable and taken properly, it will be applied. But in case of legislative actions, applying the test of arbitrariness has its limitations, court found it, because it involves inquiry into the policy decision making of the legislature. What facts went into the consideration of the legislature with the supreme or sovereign body with regard to the legislation? What was the motive behind it? What was the kind of inquiry it conducted? It cannot be inquired. And therefore, this test of arbitrariness cannot be applied. Earlier to this, there is a history that when the Constitution was framed, the then constitutional advisor, Mr. Rao, traveled all the way to America to understand the due process clause, whether it should be incorporated in the Constitution of India. He came back with the advice from the then Chief Justice of America that due process test will land the developing country into a serious problem, because the courts will start inquiring into the motives behind the legislature and the policy decision making. That may not be appropriate. Therefore, the due process clause was not incorporated in the Constitution of India. Subsequently, of course, in Maneka Gandhi case, procedural due process has been brought in. Therefore, the question arose whether Article 14 test of Rayappa, that is arbitrariness, can be applied against the legislature. In view of the fact that we are excluded substantive due process test earlier, that was a conscious decision when the Constitution was made at that time, 1950, there was reluctance to apply this test of arbitrariness. However, in the recent cases relating to Sabrimalai and others, and relating to euthanasia, the due process test has also been applied, and the test of arbitrariness against the legislative action has also been applied. The courts will have to now, if a particular statute is challenged, will have to look beyond, that is called lifting the wheel. You lift the wheel and look into the what kind of a facts the legislature had before it made the law, putting particular restrictions, burden on the individual, and for what reason it excluded others, and what reason it included a section of people in its legislative activities. So this is how the thing. But recently, Justice Chandrachud, in the case of State of Tamil Nadu versus National South Indian River Interlinking Agriculture Association, has opined that in the observations that this classification test is a formal test. It's not serving the purpose. As a result of this formal test, lots of cases of discrimination, unjustified discrimination, are going unaddressed. And in this regard, Justice Chandrachud makes a remark. This is a decision which was rendered on 21st of November 2021, just about 5 months back. And in this case, Justice Chandrachud very specifically says the courts have given overemphasis on the object of the law or the purpose of the law. This is says in the context of classification test, because this two-pronged classification test says there must be classification based upon intelligible differentia. Then the classification or the persons who are subjected to the law, that must have a nexus to the object sought to be achieved. So if you are putting a burden on X, Y, Z as a class of people, the reason why you are putting a burden must have a nexus sought to be achieved. That is how they put it. For instance, in Punjab case, one of the case, they said that boys below 25 should not be employed by the pubs and the bar. They also said women should not be employed. But with regard to the boys above 25, it was justified on the ground that they form a separate class and it has a nexus to the object sought to be achieved, that young boys should not be exposed to the pub culture by becoming an employee first. So that's how the relationship between the classification and the objective achieved. But Justice Chandrachud says in Tamil Nadu case decided in November 2021, overemphasis on this is not serving the purpose. The better to apply the test of injury, harm, or effect. If the action of the government has an effect on the particular rights of the citizen, then that effect must be tested by doctrine of proportionality. So Justice Chandrachud's recent decision is an attempt to incorporate the doctrine of proportionality, which we apply in deciding the cases under Article 19 into Article 14, which he calls as proportionality in case of comparative and non-comparative cases. That is the doctrine. The test, if applied, what happens? The problem is, which he himself has referred to an article published by Tarunab, his name is a professor from Oxford University, Tarunab Khaitan, which is published in the Handbook of the Constitution of India, published by Oxford University. In that, the author has pointed out that if proportionality test is applied for Article 14, that is to test discrimination with regard to the rights, then this Article 14 becomes confined only to the cases where there is a vested right. For instance, you take the employment matters. Nobody has a vested right to the employment in the government. Then how will you test in that case the proportionality test or the injury test or harm test? The difficulties come. In case of the rights under Article 19 or 21, it is easier to put the test of proportionality. But there is again another question. If proportionality test can be put in 19, why should one refer to Article 14 at all? So these are the questions which arise. Mr. Khaitan, he refers to the European Convention, very interesting argument he makes. If I can just pull out the thing. He says, in Europe, the European Union had an interesting clause on discrimination that limited only to the rights. And later, it was found inadequate, and they had to change the law. That he says, the European Court of Human Rights has been particularly sensitive to the parasitic dimensions of equality since Article 14 of the Constitution, 14 of the European Convention of Human Rights, only guaranteed that, I quote, the enjoyment of the rights of freedom set forth in the convention shall be secured without discrimination. That means discrimination was applied only in respect of the rights guaranteed by the convention. But subsequently, this was amended to enlarge the scope, not only rights guaranteed under the convention, even to other things. Therefore, if you apply the test of proportionality, and it is only in respect of the rights guaranteed by the Constitution, that is Article 19 or 21, there are large section of rights where people have no right. For instance, people have no right to ask for PM Kisan, the funds. That's the discretion of the government, may give or may not give. Now, in the process of doling out the grant, if the discrimination is created, then that cannot be tested by applying the doctrine of proportionality because there is no vested right. So these are the difficulties which have been encountered in applying the test. Nevertheless, the Article 14 has been satisfactorily employed in the course of last 70 years in testing the discriminatory actions of the government, particularly the discriminatory actions relating to the service matters under Article 16 of the Constitution. Large sections of the employees, whenever the government takes some action with regard to the seniority, particularly, they feel aggrieved, feel discriminated, they go to the court and the matter gets adjudicated by applying the principles of equality. There was something what happened also to the air hostess in Nargis Mirza case in 1981, when air hostesses were discriminated by retiring them at the age of 35. The court said this discrimination cannot be justified, and it was struck down. Therefore, the doctrine of equality under the classification clause has worked, though not satisfactorily, but it has done a great justice to the people in containing the administrative action, in containing the both legislative and administrative actions of the government, which are discriminatory. So with these things, now let us lastly understand who can challenge, who cannot challenge these discriminatory actions. Because the most important thing for a lawyer finally is what can be done, what can be challenged. When a government makes a law which creates a discrimination and affects the liberty of a person, the person who liberty is affected can challenge the law, certainly. Whereas, similarly, when the government doles out some benefits as a state largesse, then it excludes some section of people, then the excluded people can challenge. And excluded people can always say that the law made by the legislature or the administrative action confining the benefits only to the X class of people has left me out. Therefore, I should also be given the benefit. So the excluded category can come. In case of liberty, the persons who are included in the law, putting a restrictions, can challenge, stating that we have been discriminated by unreasonable imposition of the restrictions on our liberty. So this is how the who can challenge and what can we challenge arises. We all hope that the Supreme Court will have more cases to substantially review the classification, though Chandrachud explains it in the recent case. But application of the doctrine of proportionality beyond the cases involving vested right has to be examined, and if it can be extended to all categories of discrimination, irrespective of the fact whether one has a constitutional protected right or not, it would be of help. But again, it is a challenge, because if the doctrine of proportionality is applied to every case under Article 14, then everyone would have to challenge it only under Article 14. Probably the freedoms under Article 19 or 21 may lose importance. So these are the difficulties the courts will have to encounter, and more nuanced approach is necessary. I'm sure in course of time, we'll have many more things before the court, and many more challenging cases will be there, where this dry subject can be examined more meaningfully. Thank you very much. And I thank you all for patiently listening to the subject, which is basically a dry subject, as I started by saying.
Just checking it out. You have taken the entire session so meticulously that it is one of the rare sessions where.
I'm not sure. I'm not sure. It is a very difficult session.
Pardon?
Yeah.
No, I'm saying.
Sure, it is a very difficult session.
So it's the thing.
Yeah.
But the only issue is once you can make it out, since there are a lot of viewers watching it on the live on the YouTube. So from that, it can be gauged that people have accepted that it's a very good session. And the fact that the questions are not poured in, it also shows that you have elucidated, explained it. So people find that there's nothing more to be understood. So thank you, sir, for sharing the insightful session. And the journey in a short span has been very well explained by you. I'm just sharing the topic for tomorrow. Tomorrow's session will be a few rules of evidence and courtroom practices in receiving oral and documentary evidence by Justice Mandata Sitamurthy, from former judge of Andhra Pradesh High Court and presently the chairman of the Andhra Pradesh State Human Rights Commission. Tomorrow, do stay connected with us at 6 p.m. Thank you, everyone. Stay safe and stay blessed. And thank you, sir, for always sparing time for us.
I think some question is there.
Oh,
there is some question.
No, they're only posting, thank you for sharing your knowledge.
Okay.
Yeah.
All right. Thank you very much.